Right, let's get started. I have some slides that I'll put up on the screen today, but I kind of just wanted to open this up for discussion. I've got a bit of a recap of what we discussed at the US-Europe session last week, and then I want to kind of open it up for discussion for other topics. So I don't want to be doing all the talking. But as always, before we get started, there is the wonderful, uh, what screen can you see? Can you see the antitrust policy there?
Yeah, we can now. Yeah.
Yes.
Great. So this is the Linux Foundation antitrust policy. It's brought up at the start of all Linux Foundation meetings. There is a link there to the antitrust policy, and if you are a Linux Foundation member, you can reach out to Shane, who will put you in touch with the lawyer, who I forget, if there's any queries or questions. Moving on. So I want to discuss a bit of a recap of the last session that we had in the US. There's a recording here. I think there's also another recording that Shane sent around. I also want to talk about a workshop that, in fact, I'll cover that point now. And then again, continuing the conversation, I've got some discussion points. So myself and Dave Marr, who are both co-chairing this study group, we've kind of got a lot of ideas from the conversations that we've been having both here on this study group and in other forums. And myself and Dave and a couple of others, we're going to sit down next Wednesday and start actually capturing and documenting all of this so we can propose some form of working document back to the study group for further scrutiny and discussion. At that point, we would seek feedback on the principles that we've kind of gathered and captured and documented, and sort of build on that. But we felt as though we were doing sort of a lot of talking, and now is probably a good time to start documenting and capturing things. So the next time we meet, granted it'll probably be the day after we've had this workshop, myself and Dave and a couple of others, we may be able to present something then, but probably shortly after that there'll be a document circulated for review and scrutiny. Okay, so just to kind of cover what was discussed last week at the US session, we kind of highlighted again that OpenChain has a good platform for dealing with training policies, process, bringing in open source software, putting open source software out there. In this context here, we're in a new era. We're now dealing with AI. I'm just going to say stuff because there's things like the models, the training data, the inference data. There's a whole host of things that we need to consider. We also want to, like I say, train, define policy, define process, and then what comes out of either the AI models or the outputs of the actual algorithms or tools, how we distribute those downstream. We felt as though OpenChain was well versed at having a similar process, but now putting AI in the framework rather than open source software licensing or open source software security. Dave talked about the different regulatory frameworks, so the EU AI Act, China, and the US, and highlighted different sort of fundamental principles around each of those acts, some of them highlighting higher and lower risk AI use cases. And we may want to consider that when we are defining some principles around the use of AI. And we then touched last week on, well, what sort of use cases do we have? And we talked about, that there could be a training data set. We want to build trust in the fact that we might want to be transparent about what the training sets are. Equally, the actual algorithms, what are the weights here? Are we going to want to be open? How is it doing the interpretation of the training set and the inference data, equally the outputs as well. What's classed as high risk and low risk there, depending on if it's generative AI or just ML. They've also touched on the NIST framework, which you can see at the bottom, which highlights a number of different areas that they want to, I guess, determine how significant the principles are. And you can see around safety or security, privacy, interpretability, and ensuring that things are fair and not biased. Do we again want to utilize these principles in the framework to encourage our own open chain principles? We also touched on the fact that there are several different jurisdictions here, and OpenChain is seen as a global standard rather than just in certain jurisdictions. So we need to ensure that we are at a high enough level so we're not just focusing in certain jurisdictions there. Dave produced this model here, talking about the different use cases here for data. So we've got the actual model in this bit on the right-hand side, training and inference data. There's the model card. There's also a data card. You think about these as maybe SBOMs here. You've got different components of this whole use case that we'd want to pick up on. So focusing on the data or the training or the inference, and then if it's just going to be a user using an open source tool, again, different restrictions or principles we might want to infer in that area. Dave goes into a lot more detail in the recording, which you can talk about. So then going to last week's session, we touched on this slide, and we spent sort of 10-15 minutes talking about what do we think a high-risk artifact might be. The EU AI Act highlights different profiles for categories of models, depending on its components, very high risk, and etc. The NIST also highlights that in certain use cases, something could be classed as low risk because it's not bringing in lots of components, but if we don't have that transparency in that model, then the NIST regulation says, well, this is high irrespective of some of the components. So there is weighting on some of these principles for the different use cases. And so then we opened it up for discussion, and I'd like to do that here today. We think about these AI models, we think about AI training sets and data sets. What do we want to class as high risk here in terms of the components? If it's sensitive data, if it's code, if things are misuse or breach, that could cause more concern. So we might want to classify those as higher risks. So I don't know, open it up for discussion. Where do you think the biggest problems or the highest risk could be for the use of AI? And we had silence at the start when I proposed this question last time.
I mean, from my perspective, I'm still trying to get sort of an overall handle on what we're trying to achieve here, and I think the work that you've done is really good. And I'm sorry I wasn't able to be at the last session, but I did watch it, and that was really helpful as well. So I'm still thinking about it because I'm doing quite a lot of this sort of work with clients at the moment, and thinking about sort of useful tools for thinking that we can try to help to define the problem a little bit, because I'm slightly concerned that there is quite a significant distinction between what we are doing as far as AI is concerned and what the OpenChain project has already done as far as open source software compliance is concerned, for example. So one particular tool for thinking is saying, right, as a customer, you are acquiring some AI model, data, output, whatever it happens to be, and what are you asking for in terms of, if somebody says that they are OpenChain AI compliant, what does that mean to you? Now, we've got a pretty good idea of what that means to you in the world of open source software compliance, because it means that you can trust that the supplier has appropriate processes, etc., in place. But ultimately, it means that if you ask for the set of compliance artifacts that will enable you to fulfill your obligations internally and be able to and enable you to manage and control your risk, then you will see that obligation as having been fulfilled. So the way that I'm thinking about it is asking basically the same question as far as the AI is concerned, and thinking as a customer, what would I expect if I was going to a supplier who claimed to be OpenChain AI compliant? What would I need to get? And the difficulty is, and I think we've talked about this already, so there's nothing new here. But I mean, the fact, for example, that we're talking about the EU AI Act means that the answer to that question could be very different depending on the framework that the supplier had in mind when they were doing their work on generating the AI, whatever their AI-based activities were in the first place. So either we come up with a sort of a superset and try to come up with a superset of all of the requirements of all of the regulations, knowing that nobody is ever going to be fully compliant, with the possible exception. Actually, I don't know if you've come across the work that Software Heritage is doing. But okay, there's a sort of very slight digression, if you don't mind me talking about this, because it's really interesting. So, I mean, for people that don't know what Software Heritage does in general, it's a fantastic project where they're basically trying to get hold of every piece of open source software that they can possibly lay their hands on in all possible versions, so it basically becomes an archive, like a Wayback Machine for software. So you can look at any piece of software, any date, and you can see what the status of the software was at that stage. So you've got fantastic amount of information, transparency, and they've done some fantastic work on being able to come up with unique object identifiers to identify precisely, when you are referring to a particular module on a particular date. So their archive is sort of second to none in terms of both the content that it contains, but also the mechanism by which it's being catalogued. So they have some principles, and I haven't gone into them in great detail, but I think they generated some towards the end of last year, where they have ultra transparency in terms of what goes into the AI model, to the extent that every single bit of information that has been ingested as part of the training. Exactly the software that has been used in order to undertake that training. All the parameters that have been set to run that software, etc., etc. So, you can reach the holy grail, which we are looking for in the world of open source software, which is to have a completely reproducible build. Now, the chances of that happening in 99.999% of actual practical use cases is zero, right? We realize that is an outlier, but it's interesting that there is a project out there that has taken this extreme approach. But bearing that in mind, A, it exists, B, it's possible. The next question is, okay, so how far along the spectrum do we want and need to be in order to reach the sweet spot where we can have first of all, it has a normative effect. So people are going to want to comply with the OpenChain specification for AI, and that therefore that will modify their behavior. But they're not going to modify their behavior so much that they will take a software heritage view of this. But then looking at it on the other side, from a customer perspective, we need to make sure that the information that we're getting is sufficient information to generate the trust, and not only from an IP perspective, but also from the regulatory perspective as well. So unfortunately, that's all very open. I don't necessarily have any answers to that at the moment, but I just wanted to mention that because that's sort of the thought process that I'm going through when I'm trying to get a handle on where we are with this and where we need to go when I'm talking to clients about it.
And thanks for that, Andrew, because my next question was exactly what you've just described.
Okay, brilliant.
And we can move on to that. If you want to use generative AI, what sort of things are you looking at before using it? And I think that probably summarizes a little bit of what you were capturing there, talking to your clients about what they are looking for. And as you state with Software Heritage, I hadn't been aware of their sort of ultra transparent work, but where maybe the principles we're trying to write down are transparency that is relevant to the use case. So in some instances, we do want to be 99.99% transparent. I can't think of one off the top of my head, but in the majority of cases, 80% transparent might be enough. But one other thought that I'd had is if you sign up to OpenChain AI conformance, what does that look like? And if my company and your company have both signed up to it, I could trust you to say that the training material, is license compliant and is everything else. And I don't necessarily need to see it because we've both signed up to the trust there. So that actually reduces transparency, but because we've both agreed that we are going to meet principles X, Y, and Z, then we don't necessarily need to share X, Y, and Z. So Andrew, can you share maybe what some of your customers are interested in? Is it transparency? Is it bias? What sort of things are they
I mean,
looking at?
we're talking on a very general level at the
Of
moment, so
course.
it really depends, sort of very very much on the use case. I mean, I'm sort of concentrating quite a lot on generative AI for code generation, and actually that's where IP infringement is something that is a big concern of theirs. But then there's a question of sort of vulnerability management within code that's generated, but that's obviously less likely to be a problem as far as sort of relatively sort of small snippets are concerned. So that's where I've been sort of focusing in terms of my practical work. But the conversations about when they're using sort of generative AI for creating more textual material that could be used as sort of part of their marketing, for example. We know there are 1,000,001 possible use cases. That tends to be at a much more abstract level. So I don't have anything particularly concrete on that side of things. My focus really has been on the code generation side.
Okay. Well, again, in code generation, you can see that being a well-used use case in our industry. And it's good that you're asking questions, and it's good that customers are probably wanting to know some answers. So if there are still lots of questions out there, again, defining what we think might be reasonable for, say, code generation or other generative tools might be the starting point where we could go to the likes of you and others, and they say, well, this is too strict, this is not strict enough.
I mean, would it
But
be
it's
possible to? Yeah, sorry. I'm just wondering if it would be possible to come up with a set of profiles which can be extended from time to time, and the profiles sort of broadly try to cover the major use cases.
And that's what I was trying to get to
Yeah,
on the
yeah,
previous slide is what
yeah,
do we class as a high risk in your nomenclature use case?
yeah, exactly. Yeah, yeah.
And we don't have an answer to that. Does anyone else want to comment on what a high risk use case might look like? No. Okay. Again,
Maybe
it just
like thinking aloud here, like high risk use case, obviously cybersecurity is
okay.
one. And, I don't know if it's like code generation and then you are, crapping some bad code and that ends up in your code basically. So obviously that is, something. And well, of course, like Andrew, you mentioned the copyright infringements, I think, and that goes across the whole, I don't know, pictures, music, text, you name it.
Yeah, and I think just to be clear, we set out in the very first study group that we were really focusing our AI principles on open source software. So the cybersecurity use, military use might be, the higher risk end, irrespective of how powerful that generative AI tool is, and what the training data is. The output classification, if it's for cybersecurity, we may say this is much higher risk.
I mean, I think from an EU perspective, the way that they tend to look at those. Sorry, it's really painful having to say the way that they look as opposed to the way that we look at those issues, is thinking in terms of, in parallel with the way they look at the GDPR, which is looking at the rights of the data subject. It's broadly the same approach. So high risk from an EU perspective are any decisions being made which will affect EU citizens using AI, and that is, from their perspective, that's ultra high risk, because then that can only take place in circumstances, where all of the rights and freedoms of the EU citizen are being properly respected. So things like data protection, the release of personal data, any form of decision making their eligibility for a job, for example, what rates their mortgage are they going to be offered for a loan or a mortgage or something. All of those things are regarded as being sort of very high risk. And this is something that I think, if we generate a sort of a profile for that, it's something that is going to be very important, but it's also going to be something that's going to be quite difficult to capture, not least because the landscape is changing very much in the background anyway, and there's still a lot of thinking to be done within the EU as to exactly how this needs to be implemented. So for example, it's not, we're not only looking at the input data, the model, the way that the model has been configured, but then we get into the next stage, which is, okay, if that model is generating stuff, do we have a feedback mechanism that means that, or a filter that can actually check to make sure that those rights have been respected, to check whether there is any bias, to check whether there is any sensitive personal data that's been released, and so on. And then that's sort of fed back into improving the model. Potentially we do end up with a sort of a very large amount of sort of system complexity, because we may admit that the model has its flaws, but we're going to deal with those flaws on the way out rather than on the way in. Again, I'm not offering any solutions. I'm just presenting problems, I'm afraid. It's a very interesting problem space, certainly.
And Andrew, or I don't know anybody else, like, what was the Italian banning the chat GTP in the first place? That was a GDPR infringement, or what was the cause of? Because they banned that for a few months at least in the beginning.
Yeah, I can't remember exactly, but I think it may well have been something to do with GDPR.
See a nod from Sandra there. I think that's right. When we talked about that high risk use case of affecting any EU citizen, the EU AI Act, I'm now thinking that that is such a broad topic, or a broad use case. If you think about within the EU, what sort of use cases would not affect an EU citizen?
I mean, if I suppose if I come up with some ideas, then everyone's going to say, well, actually, it could, they could potentially affect them. But I mean, if you are sort of, merely using the AI, for example, to generate an image, a logo for your business or something. Now, the chances are, if the output is just a very small image, I mean, yeah, potentially could have somebody's picture in there, and that picture could be identifiable. But if it was just a sort of generic picture of a Christmas tree or something, that sort of thing is sort of relatively low from a risk perspective. It's really, it also really depends on the industry that you're in. You know, if you have financial services, if you have you know, medical and pharma using AI, you know, if it's used as part of a sort of employment context, if it's used within the justice system, for example, you know, these are all, you know, very high risk areas. Whereas if you're using it to create marketing copy, you know, it's I mean, there's a potential it could be sort of discriminatory or biased, but then you would say you would want an individual to review this anyway, and so that would automatically be a sort of a filter on the way out. So I mean that's sort of part of the you know the bundle of information, sort of compliance artifacts that would be required would include, and we're sort of generating essentially model cards, sort of criteria for clients at the moment, and they are questions like, you know, what tests have you done? What happens if you do detect that there is some bias in the output? How do you deal with that? Or if it's happened in the past, how have you dealt with it? And it's a sort of much more process rather than you know, getting away from this sort of pure transparency idea that software heritage is working on.
And again, if I can just pick up on that point, the OpenChain principles, again, not to get too down into the weeds of telling you what a mitigation plan is, but having a mitigation plan if you detect an error is really at the level that I think these principles should be aimed at.
Yeah, that makes sense.
So things like having a policy, again, doesn't necessarily specify what that policy is because it will be very specific to your industry and use case. Then, you know, training staff. Again, we don't need to specify what the training is, but then we could say dependent on your industry again. And again, as you utilize things, if you detect errors, if you detect any problems, having a mitigation plan in place is what we're wanting. But equally, you know, going down a little bit, and because I mean, those 3 points that I've just mentioned are very generic and could be applied to any topic. If we are focusing on AI, going down a little bit in detail around these general principles for building trust, I still see it as important. I think someone's put something in the chat. Policy and documented process to mitigate.
Yeah, that's kind of the let's say the typical open chain level of that. Okay, you have the policy, and then I don't know, there's, you know, somebody, you know, making what could be the request from outside for the open source license, whatever. Then the open chain policy or open chain specification says that, okay, you need to have documented process to handle these requests, for example. So I think, you know, the same applies with the AI requests.
Indeed. Did Mary, were you just about to say something?
Yes, we have something which is related to our topics or questions today. In our generative AI guideline, we have something which is like very direct here. For example, like the confidential information. I mean, you cannot put it in this. When you use this AI model or whatever, it's never input or upload or share this information. Otherwise, share any kind of confidential information in any public available general AI tool is forbidden. But this, how to define all of this confidential information, it's like case by case. We have an AI committee kind of team in the company to review all of these use cases. And the second part is about when using the copyright protected material as the input, make sure you only use this material in compliance with the right or the license you have regarding this material. So this is a kind of which is related to our topic today.
And I was just about to sort of question your first point, but I think you answered it in the second one. When you talk about not having confidential information being put into a training set, I would put a small asterisk next to it unless you had permission to use it. Because if I'm thinking if it's your own IP, then of course you've got that permission. You may, as a business, not decide to it. But if it's somebody else's IP, I think the guiding principle is don't put that in there unless you have the specific right to do so, which I know lots of companies, certainly image generating companies that traditionally had very permissive licenses for their content, now have changed their license to say it's permissive except to input into generative AI models.
Right.
Yes. I
So,
wanted to say, sorry.
Go on, Sandra.
I wanted to say that I totally agree with Mari. I think the use case depends highly on whether we are using the customer data or the personal data to feed an AI model as a training data, or if we are using it as an input. Because in the first case, as long as we have all the security measures in place, as long as we make sure that the AI algorithm fulfills all the criteria on transparency, biases, cybersecurity, etc., I believe it doesn't affect fundamental rights, especially because most of the models they provide analysis, they provide statistic data. So to me, it's highly different from inputting an information and expecting the customer to receive an input that makes a decision over their data. I don't know if I'm explaining myself correctly. But in the second case, that decision from the AI model can affect them directly. It can impact either the financial status. It depends on the question the customer is asking. The important thing is that the AI model is receiving information from the customer and is expecting to make a decision, a prediction over that information. So that's when I see the risk.
I think it just highlights the different use cases for the different questions are important to consider slightly different things, because the risk is much higher if it's, say, a training data set rather than an inference question.
And in the first case, even if it's a statistical data, for example, a statistical use, I don't see the risk from a customer perspective.
Can you just expand on that, Sandra?
Yes. And actually, I believe this has been an exception in the EU AI Act. When when the AI model is using personal data only for statistical purposes, it's not considered a high risk. If I remember correctly, I don't remember if this was proposed into law or it was, I remember this was proposed by the European Parliament, but I don't know for sure if it was voted into the law.
So you're saying if it's, my personal data around, I don't know, Andrew's message about mortgage rate just came to my head, but my mortgage rate and your mortgage rate and everyone's mortgage rates put into a statistical model to come up with, the country's average mortgage rates, that would be classed as acceptable because that's for statistical analysis only rather than my mortgage rate is X, Y, and Z. Yeah.
Exactly. So the important fact here is whether the AI model has the capacity to influence the customer using personal data.
Okay.
I think that's an incredibly good point, actually, Sandra. Yeah, thank you. And I think, part of the issue is, and this is where so Van Limburg's paper, for example, that he's actually published last year on sort of IP leakage. From an American perspective, the assumption is that a model cannot contain IP, and he's sort of focusing very hard on the statistical argument. Now, the problem is that I think, yeah, my recollection is that's right as far as the GDPR is concerned, that there is an exemption in there that says that if you're using the sensitive or special category personal data purely for statistical analysis, then you're okay. But the problem is that, of course, what is an AI model apart from statistical analysis? And when I started advising clients on sort of AI sort of 10, 12 years ago, the idea that we would have a generative AI, it was not something that we were really discussing at all. What they were tending to do would be to analyze, for example, a huge corpus of information involving academic papers on drug studies, for example. And then for that, they would try to analyze which drugs might be most appropriate for some condition that hadn't been considered before. And in that case, the output would be just the name of one molecule. It would be absolutely tiny, and the models were relatively small as well. But now we have this ability to generate using generative AI something that's much, much broader. Then it means that I think the EU then has to go back and revisit these original exemptions and see whether they still work in the context of generative AI. So we're coming back to the same point each time, which is the use case is absolutely critical here, and also so it's basically down to the use case, I think.
Andrew, maybe the licensing OpenChain standard better than I do. Do we capture examples of use cases in there?
I don't think we do, and I think that's something that we probably need to consider in greater depth in the next version of OpenChain. I mean, something that it's something because when I wrote the OpenChain template policy, that does go into use cases quite a lot, because I think that's absolutely vital. What I don't recall how much of that I actually imported from the original specification or not. Okay. So I think that's something that does need sort of reconsideration.
I'm wondering whether, given the fast-moving nature of AI, we would put use cases outside of a specification, so we can update that more freely. But I think from what we're hearing, examples would be helpful for the implementers of the standard.
Yep.
If we get that far. I'm not saying we will get that far.
Yeah, like Andrew, you say that I think in OpenChain specification, license compliance specification, there's no real use cases. It's just license compliance and how to have the processes and policies in place to get there.
I think the first step is to define the what, similar to the open source license compliance, for example. We have the clear what there. You must have this in place. Then it means you are compliant. You can prove that you are compliant. And for this generative AI part, we probably need to work on to define the words.
So can we just pick up on that point? Because I think this is important and crucial to what we're trying to achieve, what the what is. We have lots of good discussions, but what do you think the what is, Mary and others? Do we want to state what we think it is and then open it up for discussion?
I think it's a good idea. I think it's like define the what, then it's the how, right? Without the what, then you don't know what it's the compliance is. But I don't have the answer now, but I can think about it after this meeting so we can work on it. What do you think, everyone, like in your mind, what is the AI compliance part? Then we can merge all of this answer together to discuss in the next meeting.
And that's kind of the crux of my top bullet point here. And actually I've got 2 more slides, but the last slide is the how. And I've always thought that the how is definitely outside the OpenChain remit, and I touch on the SPDX AI working group that are working on the how. But defining that what, I think, is the crux of what we're trying to achieve. And we have a few words around input, whether that's a data set or data card, We have the model, we have the output, we have feedback. Then we have high risk and low risk use cases, but then it's what are we looking at in each of those? And we've touched on transparency, we've touched on bias, and we should work on that. Does anyone else have any other comments on that?
What we can start to look at is, you know, in the SPDX standard, the version 3.0, 3.0, they start to include the three areas. First one is about life compliance,
I have that on here.
Security compliance, and they have the AI data there as well. So what is that AI data there? Is that kind of similar to the compliance definition or not? So that can be a start point to look into it.
So for those of you who've not seen this, this is, I think, what Mary was referring to, the SPDX AI and datasets profile. These are the sort of fields that they're looking into
Yes.
for the model and the data. And I can share this link around. It's in the slide deck. And this is Karen Bennett's slides.
Yeah, I really like the question you listed in previous your slides. I will kind of bring this to our AI generative team as well internally to see if I can get more information from them.
And yeah, I mean, each sort of company or in Andrew's case, you know, companies you're working with, they're going to make their own business decision on what is acceptable and what is not acceptable. But those overarching principles are probably what we're looking for in terms of the words. You know, I look at IP protection rights as an example. If we are going to, if my company is going to lose the IP, any IP protection rights, we've made a decision that we're not going to accept this as generative AI. An example would be putting our code into a public generative model. So IP rights is a category that we consider when making a decision on whether a use case is acceptable. You know, if somebody wants to bring in another model, we want to ensure there's good security and there's good. We're well aware of it. And I will just bring up this document. This is a public document from ARM. Again, I can share the link around later. This is our trust manifesto that was created in 2019 on AI. And we highlight certain key points around what we consider as good ethical principles in the trust of AI. And this is around security, eliminating any bias. We touch on sort of people, human safety, decision making, and this one's around transparency. So this is publicly available and people can read about this. And these are kind of our overarching principles of how we accept trust within an AI system. But I was curious to hear if there were any others from other parts of the industry about what are the things people consider about, again, that defining that what.
This is quite an interesting topic. It's new, but it's really interesting to work in this to define the word together.
Indeed. I mean, I don't know what the general consensus is. To my second bullet point on the screen, I'm still sharing my screen, aren't I? You can still see that. You know, do you think companies should have an AI policy? Is that something we could specify in an OpenChain specification or guiding principles?
I think broadly the answer is yes, but the problem that we have is that we're moving a very long way away from the principle of open source. And in a way, the problem as far as open source is concerned is sort of reasonably straightforward, because we know that if, even without knowing the license, we know that if we have a piece of software that's available under an open source license, we know that we automatically have certain rights that deal with that. And the original OpenChain specification was intended to cover both open source and licenses similar to open source. But we know, but at the time, the assumption was that the licenses that are similar but aren't technically open source are either ones that we can treat as open source, like code under the JSON license, for example, or we have to take it as being a separate use case, such as code under the Commons clause, for example. We could take the assumption that any code base that we're provided with, vast majority is going to be open source specifically, and therefore there are going to be some sort of fundamental principles. Now, if you look at the terms for sort of Google's Gemma, for example, it's very, very clear to say this is not open source, and it says there are good reasons for this, and that's because it has an ethical policy sort of use restriction, which is obviously the use restriction that's directly contrary to the open source definition principles. But that's fine, because that's, it's important that we have that sort of thing. So in terms of our own terms of reference, we have to be very clear as to, and again, this is sort of in parallel with work that's being done at the OSI, for example. Google's obviously thought about it themselves. I mean, this is, we're not in isolation thinking about these things. But we are going to end up with our remit being quite divergent from a pure open source remit. And I think it has to be. I don't think there's any way around that, but we just need to be sort of aware of that fact. Again, so if you're talking about sort of the ethical principles, we need to sort of determine whether those, there is a sort of common subset of ethical principles that we would expect people to have, and that's partially driven by the regulation. I mean, one would like to think that Google's imposition of these ethical principles is because it's going back to its do no evil roots. And I would like to think that's the case, but obviously it's a commercial organization, and it's existing in a context of a lot of regulation, which but also it needs to be seen from a marketing perspective, to be seen to be doing the right thing. So I think in this case, I think this is where this diverges from open source, is that we are going to have to bring some of these ethical principles into our thinking, but we've got to be quite careful that we know what we're doing when we do that.
I mean, when you said we need to focus on open source, yes, that's what the principles are, but the licensing specification and standard says that you should have a licensing policy. Is that right?
Well, the OpenChain specification, yes,
Yeah.
it says that you need to have a policy, and that you need to be aware of the characteristics of the major open source licenses, etc. And where it gets sort of strangely specific now is that it also talks about sort of specific use cases. You need to be aware of licensing obligations when you're distributing a binary. You need to be aware of licensing obligations when you're linking two pieces of code, etc., which is sort of strangely specific. But there are good historical reasons why that's in there. So I think we need to think along sort of similar lines as far as the AI specification is concerned. But if we are bringing in, I mean, the one thing that the OpenChain specification, one thing it doesn't talk about ethical principles, because that would be completely inappropriate to talk about ethical principles in the context of open source licensing, because ethical principles are automatically in conflict with the open source definition. And we know that, and that's not to say we don't believe in ethics, but it's to say that it's somebody else's job to deal with the ethics. We're here to sort out license compliance. Now, we have the license compliance issue as far as AI is concerned, and we're going to be tackling that. And that's reasonably well-trodden path, because we're familiar with doing that when it comes to open source licensing. But because of the regulation and everything else, we're now moving into this additional territory that we have less experience of, which is the ethical side of things. And saying, if we have an ethical policy, what are the characteristics of it? How deeply do we go into that? If we were, by analogy, to go into the depth to say, well, we need to, I mean, as the OpenChain specification, as I said before, you need to think about the legal effect of linking two pieces of code. Do we need to get into a similar level of detail as far as the sort of ethical section of an AI policy?
The way I was thinking, and it's obviously open up to the community and discussion, and please critique it, is that we would state that for good AI work, the word's gone out of my mind, you would have considered transparency of the source code, and you would have considered any biases. It doesn't say what the biases are and doesn't go into the level of detail of what transparency would be, but it would be slightly lower than, well, in my opinion, we would have an ethical implication in this standard. And we would probably go down a level to say, you need to consider X, Y, and Z. Now, if somebody says, I've considered it and I don't care, then that's specific for the company and their use case. But providing that guidance and knowing that a partner of my company has considered that is what I'd be looking for.
Yeah, that makes perfect sense, and that would be analogous with the community policy, the community contribution policy that exists in the OpenChain compliance specification, and it's perfectly valid to have a policy that says we never contribute to any third-party projects.
Indeed.
Yeah, so that makes sense. Yeah.
We're getting towards the top of the hour, and I'm well aware that Haley and the other Andrew hasn't said anything. Do you guys want to add anything to the discussion?
I've just been thinking about the kind of outbound licensing side and how I'm not massively familiar with the kind of OpenChain compliance. I'm quite new to working on this, but I was kind of thinking more around how they kind of, with open source, obviously we've got these kind of model licenses that we all know and we're very familiar with, but I didn't know whether there's any work being done on the AI side on that. If there's because my experience is that all of the things I'm looking at are fairly, I mean, there's the obvious open source ones that come out under like Apache, and I've seen some MIT ones, but I'm finding a lot of them are proprietary, and they're very kind of specific, and they have exclusion, lots of restrictions and things you can't do with the models. I don't know whether there's any work being done on the kind of standardizing, kind of open licensing of AI models, and whether the kind of existing open source licenses are appropriate.
I think there's work on open AI licenses. The Open Rail one comes to mind. But what I'm actually seeing with the evolution of some of the large models is they're actually going from more open source transparency to becoming closed source. As you look at the evolution of ChatGTP 1, 2, 3, 4, whatever on now, the early ones 1 and 2 were very transparent open source license, and now they've added clauses to make them not open source. Maybe this is just the way the industry is going with this new technology.
Yeah. Because it makes kind of reviewing them quite difficult. You've got with open source, it's quite, you kind of know automatically what applies, but with the AI model use, it's a bit of a minefield, as we all know. I don't know how much that comes under what the remit of what this project kind of relates to in terms of the outbound licensing.
I don't think it comes under OpenChain, but Andrew Katz, are you aware of anything in OSI that is looking at that? You're on mute if you're about to talk.
I think it's sort of coming out as far as their sort of general discussions are concerned about sort of definition of OpenAI, and clearly the sort of licensing model is important there. I mean, you mentioned there's sort of already been work done on some licenses, and a lot of people are just applying just standard open source licenses. But I mean, but the regulation is sort of tending to force the larger providers down this more restricted route as well. So I mean, again, the question would be, what are we trying to achieve by producing an open license? And if it was a pure open source license, then that's pretty straightforward, and a variant of an existing license like Apache would be quite straightforward to apply. But then you do have the additional problem of applying sort of regulatory constraints to that as well. I mean, I'll put there's the GEMA prohibited use policy, which is sort of quite instructive, and Google has some quite useful commentary about why they've chosen to use that and not a pure open source license.
Okay.
We're getting to time now. Any last comments from anyone? No. Okay, so we do have a US Europe session next Tuesday. As I said, we're going to have a bit of a workshop on the Wednesday, and then when this group meets again in 2 weeks' time, we can give some updates and carry on the discussion. But I think this has been very helpful. I think defining the what, as Mary points out, is going to be crucial to the success of creating these principles. And I think we've started that discussion today, and we will continue it over the next few sessions. Okay. So thanks for your time, everyone.
Thanks, Matthew. Thanks, everyone.
Thank you.
Thank you very much.
Okay, have a good
Thank
day.
you.
Bye.
Bye-bye.
Bye, everyone.
Bye-bye.